Hi. Because for the purpose of your exam you need to know the law as it is at a particular date in February, about the 14th I think, it's important to know about things that have happened since the last edition of the module guide. So the University of London publishes what they call a pre-exam update, which you can download from the VLE if you haven't already got it. You certainly need to have a look at it. I'm using it as the basis for this lecture. The latest version of the module guide is dated 2019, but I'm not sure when in 2019. I'd always assumed it was going to be about September, but there are one or two things that make me think twice about that now. I'm mostly following the scheme and the content of the pre-exam update, but if I'm reproducing anything from it, it's ideas, not expression, and I think in any case I can say that this is reporting current events, so there's a little bit of copyright revision for you. My feeling is that there's not a huge amount of significance in the pre-exam update, but there are some important cases from the Court of Justice which are still going to impact on the UK, notwithstanding our having left the European Union, and there are a couple of Supreme Court cases which I think are of particular importance. Well, it's a bit of an obvious thing to say, really, isn't it? Because if they're Supreme Court cases, they must be important. However, they both involve patents, and I know how students generally feel about patents. The university's pre-exam update follows the scheme of the module guide and uses the chapter headings. So it begins by talking about sources of intellectual property law, and it tells you quite a lot about EU legislation. To my mind, it's more than you need to know for the exam. If you're practicing intellectual property law, then you need to know a great deal about this, but for the purposes of your exam, very little, if anything, has changed. Next year is likely to be a very different story. Well, as we all know, I hope, the UK left the European Union on the 31st of January 2020. I made sure I was out of the country at the time so I didn't have to see people celebrating it. There's a transition period up until the 31st of December 2020. The government is still saying at the moment, and it's the 2nd of April when I'm recording this, that notwithstanding the fact that the whole world has come to a complete halt for several months, it's not going to try and extend that. We shall see. Anyway, the upshot is that in spite of all that good stuff in the pre-exam update, no practical changes will take place for the purposes of your exam, and we'll wait and see what the 2021 pre-exam update says. Well, you won't, because you'll have done your exam and moved on by then. I suggest you don't spend too much time thinking about this particular part of the update. Instead, let's move on and look at the cases, and the recent developments are nearly all cases that the pre-exam update mentions. Beginning with breach of confidence, a case called Bull and Desport. Note that the pre-exam update cites the case wrongly, so I've given you the correct citation on the slide. It dates from the 26th of June last year, so this is an indication of many of the cases, the same could be said about them. Why this didn't get into the module guide in the first place, I'm not entirely sure. Is it a very important case? Well, I don't think it is. There's some useful stuff in it, but unless the examiner's particularly chosen to ask a question based on these facts or similar facts, I can't see that it's going to feature in any exam answers. It involved Mr. Bull, who'd won a lot of money on the lottery, had an affair with Ms. Desport, and she decided to write a book about it. So he sued her, amongst other things, for a breach of his right to privacy, or, well, strictly speaking, misuse of private information. There were also libel claims going backwards and forwards. It seems to be a rather unedifying state of affairs. The important contribution it makes to legal scholarship, if anything, is the judge, Mr. Justice Knowles, holding that there is little or no public interest in the details of someone's private sex life. And of course these misuse of private information cases all turn on the question of where there's a public interest and does it outweigh the right to privacy. Does it make any difference whether the information in the book is true or false? The judge said it's not relevant to considering whether the information is private. That seems to be correct, but it does seem to be mixing concepts. Privacy and accuracy or truthfulness don't necessarily go very much hand in hand. But whether the information is true or not may be relevant to the public interest balancing exercise which has to be undertaken in cases like this. There wasn't a great deal of balancing to be done in this particular case because the public interest was so difficult to see, and consequently the judge found in favour of Mr. Bull and awarded damages which, in the context of the amount he won on the lottery, were pretty insignificant. Next we need to consider a very important development in copyright law, which actually is going to be utterly unimportant from the point of view of the United Kingdom. So again, we don't need to spend a great deal of time on it, but if you're interested in intellectual property, and particularly copyright, away from the pressing context of the examination, then the Digital Single Market Directive is very important. Having said which, I'm not going to go into it in any more detail now. It was made on the 17th of April 2019, came into force on the 6th of June, must be implemented by the 7th of June 2021, by which time, of course, you can't see the UK for dust. Because of the implementation date being after Brexit Day, the directive does not form part of the acquis, the body of European Union law which the UK has got to carry on with. It might be thought that it would make a great deal of sense to say copyright law is a bit out of date, it's not dealing very well with some of the issues that arise in the digital world, and look, the European Union's produced a good model, well, arguably a good model for law to deal with it, so why don't we just put it into our law anyway? The UK government might also say we put in a lot of work in the European Union institutions when we were members. We persuaded a lot of other member states that this directive was a good idea. They were reluctant to have it, so to a large extent we're responsible for it. Why do we now think that we don't need it, which is what the government have said? They've announced that following Brexit they have no obligation to implement the directive, and they're not going to. I don't imagine the examiner is going to ask you anything about that. There could be some scope for mentioning it if you got a question about copyright law that raised some sort of digital context where the directive might be relevant, and you'd have an opportunity of saying that this is the state of the UK law at the moment, answer the question by reference to that, and then say something about the directive and what it would do to the issue that you've been writing about in the exam. But that's not the sort of thing that the examiner does. So, interesting as it is, I think you can park it. There are a few cases on copyright from the Court of Justice, and these are matters which definitely form part of the acquis, and therefore you need to pay attention to if you're answering questions about them in the exam. And I can just see a mischievous examiner throwing in a question about originality, so that you have to take account of some of these decisions, or what constitutes a substantial part of a copyright work, or copyright protection for designs. All these are issues which the court has considered. So, first of all, the Funkimedian case, copyright in military status reports. That's a new one on me. The question is whether they are sufficiently creative to be protected by copyright, and the court's answer is no. And the reason for that is because the content of these reports is determined not by the author, but by the information that they're trying to convey. So there is no creative expression, which is what copyright's interested in protecting. The information and the expression of the information are, in this interesting word that the court has invented, indissociable. Well, actually, the court hasn't invented it. According to the Oxford English Dictionary, it means incapable of being dissociated, although it only gives one example of it being used from 1855 in a book about psychology, and it tells me that it comes from the ecclesiastical Latin. Why is the Court of Justice using ecclesiastical Latin? Well, okay, I think we can see what the court's trying to get at here. The reports are entirely characterised by their technical function. There is nothing in these military status reports that is not dictated entirely by the information that they're trying to convey. So there's no scope for the author to express any creativity in an original manner, so military status reports are unlikely. Of course, it's not the Court of Justice's job to make findings of fact, so we'll just say it's unlikely that they would ever be the author's own intellectual creation. I think in those bullet points we've got probably 4 different ways of saying pretty much the same thing. And what it comes down to, effectively, is that there is not going to be enough originality here to constitute a copyright-protected work. In fact, the way that this issue is addressed under European Union law is to say that something that's not original can't qualify as a work. And we'll see that in some of the other cases that need to be talked about in this presentation. And that raises interesting and important questions about whether the UK approach to copyright actually conforms with the EU approach at all, because we have what's called a closed list copyright system. We stipulate what sorts of work can be protected and then say they've got to be original, whereas other jurisdictions and the emerging EU copyright law, which is based on the 2001 Directive, take an open view about what can be admitted to the copyright system, and whether it's original or not is the crucial factor. The Court of Justice wasn't actually asked in this case by the referring court, which was the Bundesgerichtshof in Germany, about originality. In fact, there are 3 questions, of which the interesting one seems to be about whether the 2001 Directive amounts to a complete harmonisation of certain matters, which is a rather indirect way at arriving at the important issue here, which effectively comes down to a simple question of originality, which is what's really interesting from the point of view of a UK copyright lawyer. The Coffermel case dates from the 12th of September. I made a particular note of the date of the Funkemedian case because the 29th of July we've got 3 cases all with the same date, I think, which is interesting in itself. Anyway, Coffermel is different. It too elides these 2 questions of originality and the definition of a work. It's about copyright in designs, in this case designs for clothing which have been commercially marketed. The clothing in question comprises jeans, sweatshirts and t-shirts. So I've noted on the slide that these were the items in suit, by which I meant involved in the lawsuit. Then I thought that's a bit ambiguous because we're not talking about suits in the clothing sense, and then I thought, what the hell, we'll leave it in there anyway because it's quite amusing. Anyway, so in suit, jeans, sweatshirts and t-shirts. Not exciting designs, I think it's worth saying. The case was referred by the court in Portugal, so where issues of national law arise, it's Portuguese law, but that doesn't affect the statement of the Court of Justice, which said that if you're going to have something protected by copyright, it's got to be a work and it must satisfy the conditions in the Lavola Hengelo case if it's going to be considered to be a work, it must be original. And when in European speak we say original, what we mean is it's the author's own intellectual creation, and it must constitute an expression of that originality. And that, as far as the 2001 Directive is concerned, because that seems to be the fundamental document of European Union copyright law, whether it should be or not, I think is another question altogether, because it's only supposed to deal with copyright in the information society, but the Court of Justice has taken it as a fundamental document. That's the only requirement that can be imposed. So again, it raises questions about whether the UK is right to have a closed list copyright system. As far as the Court of Justice is concerned, there can be no further requirement for any aesthetically significant visual effect. It's not relevant to the question of originality. It cannot be required in national law. So you can't say that an artistic work to be protected must have some sort of artistic merit. You can't say a design has got to be aesthetically pleasing if it's going to be protected by copyright. That's incompatible with EU law. Where that leaves UK copyright law is a whole different question, and we'll come back to that shortly. The traditional way of breaking down copyright into issues of what types of work are protected, what's original, what's a substantial part, all those are breaking down as the Court of Justice makes greater and greater inroads into the copyright area. It's quite fascinating to see what happens, and also something of a relief that we'll be watching from the sidelines rather than participating in it. Not that I think it's a sufficient reason for bailing out of the European Union altogether. Anyway, that's the Cofemel case. Next, I want to depart from what's in the pre-exam update slightly to mention another case that's relevant to these issues, the Brompton bicycle case, in which the Advocate General gave an opinion on the 6th of February. So it's within the time frame for the exam, whether or not it's within the time frame for the UK having to follow it. This is a reference from a Belgian court, the court in Liège. So it concerns Belgian copyright law. You won't be surprised to know that the folding mechanism for the Brompton bicycle was patented, but a long time ago, and the patents have expired. But it's also such a great idea that lots of people want to copy it. So if there's no patent protection, Brompton are going to be looking for other forms of protection, and copyright is one of them. However, the Advocate General looked at the issue of originality here and said that the shape of the folding mechanism is dictated entirely by the function that it has to perform. Consequently, although the Advocate General didn't use the words, there is no design freedom. There's no scope for the designer to be original and creative here, and in the absence of any originality, you haven't got a copyright work. Well, we've got to wait and see what the Court of Justice says, but it seems highly likely that the Court of Justice is going to follow what the Advocate General said. The Court usually does, although we've got one case in this tour d'horizon of the recent cases where the Court has not gone as far as the Advocate General. Come to that later. To my mind, this raises the question again whether Directive 2001/29 should be referred to at all in situations like this. But I've got a feeling it's a bit too late to be asking that question. Next, going through these cases in the order that the pre-exam update presents them, we've got a Court of Appeal decision. It's almost a relief to get away from the Court of Justice. In Martin and Cogan, which is the case about the screenplay for the film Florence Foster Jenkins, the Court of Appeal reversed the judgment which was handed down by His Honour Judge Hakon, I think, in Intellectual Property Enterprise Court. Yes, I remember it was Richard Hakon who did that. It's mentioned in the module guide, paragraph 7.5. So if you need to refresh your memories, what we're talking about here, go and look at that. but don't look at it too carefully because it's all old hat now. It's been overtaken by events. The Court of Appeal said you need to have, there are 4 conditions that have got to be met for a claim for joint authorship to succeed. There has got to be collaboration, there has got to be authorship, there has got to be a contribution from all the purported joint authors, and there has got to be some non-distinctiveness of that contribution. If individual people's contributions to something are distinctive, or distinct, I think is probably the word. Should that be distinctiveness or distinctness? Anyway, I think you know what I mean. If the contributions are distinct, then you don't have a work of joint authorship. You have, 2 people producing things that go together. 2 entries in an encyclopedia, perhaps. But if you can't distinguish one person's contribution from that of others, then you have prospectively a claim for a joint authorship, provided the other elements are there as well. On the facts of the case, one party did have the final say on the form of the work, but that's not conclusive. It doesn't mean of itself that authorship is not joint. Who won the case is not usually something that you need to worry about too much, because that's not what the examiner is going to be interested in. The examiner is going to be interested in you understanding the legal principles. And here, in fact, we don't have a winner anyway, because what the Court of Appeal did was send it back to the judge to have another go, with the benefit of the guidance that the court has provided. So we've got to wait and see who's going to win that. It comes down to the Court of Appeal saying that that it's really a matter for the trial judge to look at the evidence again, which is not something that the Court of Appeal is set up to do. So moving on, with a pause so that I can change the slide. We're back to the Court of Justice, and we're back to the 29th of July 2019, when it did so much work in the copyright field. The Pelham case involved an extract lasting 2 seconds from a recording by Kraftwerk, a band whose music I've got to confess I've never really got into. Well, why did I say really? I've never got into it at all. The question for the court is whether a 2-second extract, a sample, amounts to what, well, in UK law we would regard as a substantial taking from the copyright work, but in terms of what the Directive, which is 2001/29, again says, the question is whether it is reproduction in part of the recording. Certainly not reproduction of the whole of the recording. There's no suggestion that that should be the case. It's only 2 seconds out of a much longer recording. But does 2 seconds amount to reproduction in part? And this is where the Court of Justice and the Advocate General have differed. So we'll start with what the Court of Justice said, because that's what becomes law. The Court of Justice says the extract has got to be recognisable as part of the recording. The Advocate General was rather more sophisticated about it, and I don't mean that as a way of saying that the Court of Justice got it wrong. It may be that the Advocate General was too clever, but the Advocate General's argument was that as far as sound recordings or phonograms are concerned, the law doesn't stipulate any threshold of originality. In UK copyright law, a sound recording is protected provided it's not a copy of an earlier sound recording. But incidentally, back in the days when the courts would say originality just means a lack of copying, it always seemed to me that those two things meant the same. However, in the EU, it's definitely different. So the Advocate General said there's no threshold of originality here. You can't identify what's too small or insignificant not to amount to an infringement. Therefore, even 2 seconds or less will amount to an infringement. The lack of any sort of originality threshold produces this, well, I would have said potentially absurd looking result. And it leaves us with very interesting questions about how this is going to work in the UK, where we don't talk about reproduction in part, we talk about taking a substantial part of the sound recording. Again, the fact that the sound recordings protected without any originality requirement in the UK, other than the not copied requirement, could lead you to the same conclusion. It's a bit complicated because there's not only going to be a sound recording copyright involved, but there'll also be a copyright in a musical work, and that is going to produce a rather different answer because originality is important there. But at least the use of the word substantial in the UK statute opens the door to applying a quantitative test, even if a qualitative one is going to be rather difficult to work. And I suppose people who would like to use samples from other people's sound recordings in their work will take this as an indication that they need an express permitted act inserted in the copyright statute, whereas boring people like me might say, if you want to use somebody else's work, then why don't you just pay for it? And if the owner of the copyright isn't prepared to do a deal with you, then that should be the end of the story. If you've got a critically discuss essay question in the exam touching on this, there's so much you could say. Well, the Pelham case crops up again in a different context, and side by side with a case involving Spiegel Online, and it involves Article 5.3d of the 2001 Directive. If you don't immediately know what that deals with, and who can blame you, it's allowing quotations, and it has its parallel in the Copyright Designs and Patents Act in Section 31ZA. The presence of Z sections in a statute being a fairly clear indication that it's in dire need of being replaced by something that consolidates everything. Anyway, a copyright exception, and I think the directive uses the expression exception for quotations, is something that exists in EU copyright law. In the UK there's a fair dealing exception, a fair dealing permitted act rather, so it's an overriding requirement of the UK law that if you're going to take advantage of the permitted act for quotation, it's got to amount to fair dealing, which basically means not contrary to the interests of the copyright owner. Well, here we've got two decisions from the Court of Justice on that from 29th of July. In the Pelham case, exploring the scope of what amounts to a quotation, saying that the purpose of a quotation is illustrating an assertion, defending an opinion, or allowing an intellectual comparison. And on that basis, the Court of Justice could say fairly easily that sampling has got nothing to do with quotations. The interesting point in the Spiegel case seems to be that the Court of Justice accepts that including a hyperlink leading to another document can fall within the scope of a quotation and therefore can be permitted for copyright purposes. The court also took the opportunity to elaborate on what lawfully made available to the public means in this context, but I'm not sure there's anything very interesting in there, and there's a lot more material to get through, so I think I'll speed up and just pass over that. You can read about it in the pre-exam update, and you can even go and read the judgment if you want to. Next, under the heading of designs, the pre-exam update takes us back to the Cofimel case and reminds us that the Court of Justice held that designs could be protected by copyright, but that no additional aesthetic requirement could be added to the basic threshold of originality. So the pre-exam update then asks how this works with works of artistic craftsmanship under UK copyright law. In order to be a work of artistic craftsmanship, something has got to be artistic and it's got to have craftsmanship in it. So the question arises whether UK law is imposing requirements over and above those inherent in the concept of a work for EU copyright purposes, and therefore failing to comply with the directive. Now, it's interesting that in the pre-exam update, the author presumably Professor Griffiths should have seen fit basically to pose this question. I'm afraid I have no inside knowledge of how the exam's put together, but the fact that the question's appearing in the pre-exam update may lead you to think that it might appear in the exam as well, in some form. I'll leave you to think about that. We've got one design right case. It's a judgment of Her Honour Judge Melissa Clark in the Intellectual Property Enterprise Court. As I'm sure you're aware by now, although IPEC is specifically designed for small claims, it is certainly not limited to unimportant claims, and there have been some very influential cases which have come out of it. Having said that, I don't think this is one of those really important cases, but it does tell you one important thing, that in order for there to be an infringement of design right, the defendant must copy the whole of the design exactly or substantially, which is very different from the copyright test, which says that you must copy a substantial part of the work. Just to put it another way, you're looking for substantiality in the copyright world in terms of how much of the work has been taken, whereas in the design right world the substantiality test is applied to the copying which has taken place, not the design. Quite important because in so many respects copyright and design right are very similar. The judge also considered what the effect of taking out the words any aspect of from the definition of a design. That was done by the Intellectual Property Act 2014. To me that's still very recent, but to you that's ancient history, so you're not really interested in the changes that took place all those years ago. However, it still remains important to be able to recognise what part of an article is, and part of an article has to be an actual part, not an abstract part. It has to be identifiable, and it has to be not trivial in the context of the article as a whole. That's quite a useful and helpful summary of the way the law has developed since design right came into existence. Next on the agenda is a passing off case, and it's a classical passing off case. Glaxo Wellcome against Sandoz, a High Court judgment of Lord Justice Arnold, which, if you watch the IP world closely, will raise two questions. First of all, why is Richard Arnold doing this when he's now a Lord Justice of Appeal? And secondly, how long is the judgment going to be? The answers to those questions are, first of all, that it seems he's still the judge in this case because it started as long ago as 2015, long before he was promoted to the Court of Appeal. And secondly, 316 paragraphs. He doesn't just do it because he's got a reputation for long judgments to keep up. This is a passing off case, as I've already said, and therefore very fact heavy. There's a lot of evidence, there's a lot of witnesses, in fact far more witnesses than I think the judge would have liked to have seen. But at the end of it, a fairly straightforward outcome which should have been entirely predictable. So I'm going to suggest that you refrain from reading his 316 paragraph judgment, as if you needed me to urge you to do that. So Glaxo claimed to own goodwill in the purple colour of an inhaler that they make for treating asthma. Sandoz used a purple colour for their similar asthma inhaler, and they argued that it was important to use the colour purple, not because it took advantage of Glaxo's goodwill, but because it was an industry convention for treatments of this sort. Well, speaking as an occasional user of inhalers, although not this particular one, I can say that the colour is pretty unimportant to me, and I don't associate it with any particular manufacturer. I am aware, though, that there is some sort of colour coding that goes on in this field. And I think the really powerful inhalers that have got steroids in them tend to be brown. So I can see a little bit of validity to Sandoz's argument, but I'm not entirely convinced. Anyway, the point is that in this case the evidence didn't show that the colour had come to be recognised as an indication of trade origin. And certainly in this country, you go to your doctor, you get a prescription, you take it to the chemist and they give you whatever's in the prescription, and you don't care who made it or what colour it is. You certainly don't have any choice in the matter. Had there been any actual confusion, you don't need to have confusion to establish a passing off, because what you need to show is misrepresentation. But if you've got confusion, then it certainly supports the claim that misrepresentation has taken place, and in this case there was no such evidence. So having told you it was a very evidence-heavy case, hence its extraordinary length in terms of the judgment, there wasn't any evidence to get Glaxo anywhere near where they wanted to be. Does this tell us anything new about the law of passing off? I don't really think so. It's nevertheless a useful illustration of the way in which these things work. Next we go back to Luxembourg, to the Court of Justice, for a trademarks case. This is a European Union trademark application which has gone on appeal from the EU Intellectual Property Office to the General Court, and from the General Court to the Court of Justice. And it concerned a trademark consisting of a combination of two colours. Now, you should be aware of the requirement in the trademark legislation. We find it in the Act because it comes from the Directive, and the Directive and the EU trademark regulation are pretty much the same in these respects. You've got to be precise in the representation of the trademark that you file in your application. So you've got the two colours, and there's no argument about whether the colours are properly defined or not. Normally you would do that by reference to a Pantone number, but that's not the issue here. The issue is that the verbal description applied to the trademark says that the two colours are approximately 50% and 50%, that they are juxtaposed in relation to each other, and that they are in equal proportions. The court said that's not precise enough. You need a specification of the spatial arrangement. Giving one trader exclusive rights over a particular colour or even a pair of colours is a pretty powerful thing. So registering trademarks like this is something that's got to be done with care. I don't think Red Bull did very well when they used the word approximately, and I think they needed to explain what they meant by juxtaposed a little more clearly. So the important thing from the point of view of the legislation is that trademarks can only be registered if the application contains a representation that allows the subject matter and the scope of the subject matter to be clearly and precisely defined. Red Bull's appeal to the General Court had failed, and its appeal to the Court of Justice failed as well. They upheld the General Court. I think that's a more important decision than it might at first appear, because this whole question about precision in trademark applications is so topical. And that brings me to another case which isn't in the pre-exam update, but which I think is important enough to draw to your attention. Sky against Skykick. Sky had a registered trademark for inter alia, which is what IA stands for, computer software. Very often trademarks get registered for wide ranges of goods and services, and then not used. They become vulnerable to revocation after 5 years non-use, but that's an imperfect instrument for getting rid of them when they're not used. And anyway, I don't think 5 years non-use was an issue here. Skykick is a cloud computing company set up by a couple of people who used to work for Microsoft in Seattle, I think. Sky, not surprisingly, didn't like this, or didn't like their choice of name. I think they were perfectly happy with what they were doing. So there was an infringement action. Skykick challenged the trademark registration, and they challenged it on a number of grounds, including the fact that it was pretty unclear and imprecise, that there was never any intention of using the trademark for computer software. And the Court of Justice, actually I think ducking a lot of the issues which the Advocate General dealt with much more satisfactorily, but that's a whole different story. The Court of Justice held that a lack of clarity and precision in a trademark specification is not of itself grounds for invalidity. I think those words "of itself" are quite telling, but of course the Court of Justice isn't dealing in certainties, it's dealing in interpretations. So that's something that would still be up to the National Court. Importantly, it says that the absolute grounds for refusal of registration set out in the Directive are exhaustive. You can't add anything more to them. You can't assume that there's another one to do with lack of clarity and precision that just hasn't actually been written into the Directive. So that list can't be extended. But it's not impossible that that the lack of clarity and precision might lead to invalidity. Probably more important, registration without an intent to use may be evidence of bad faith, and bad faith is really the way to attack a trademark registration like this, which is too wide. The Court of Justice also went on to say that the requirement on the UK trademark application form TM7, for the applicant or their representative to declare that they're using the trademark or intending to use it is okay, which is probably a relief to the UK Intellectual Property Office. So that's a case which doesn't appear in the university's update, but I think you ought to know about. Now, you're aware that at the beginning of last year, 2019, there were big changes to Trademarks Legislation. Of course, you're learning the law as it is now, so you don't need to know about what it used to be or what the changes were, really. But the old absolute grounds for refusal, which related to shape trademarks, have also been extended to cover other characteristics of goods to which the trademarks applied. Incidentally, the Trademarks Registry has been able to think only of one possibility here, which is that sound trademarks could be subject to this. The sound seems to be the only other characteristics that anybody can think of that might be brought into the legislation by this change. Anyway, in the Textalis case, not a UK case, it came from the Swedish court, and importantly also it's an EU trademark matter, so we're looking at the EU trademark regulation rather than the directive, although the substantive law is exactly the same. The trademark was a fabric design, and the trademark was challenged in infringement proceedings by the defendant on the basis of, well, Article 7.1e of the regulation, Section 3.2c of the Trademarks Act 1994 is the equivalent. And what happened here? No decision really on the substantive law at all. The court simply said that the amendment specifically protected the position of existing trademarks, so no trademark already on the register became invalid because of the extension of this absolute ground for refusal, the result of which is that EU trademarks will remain on the register even though they couldn't be registered if they were applied for now, which strikes me as a pretty bizarre state of affairs, although I suppose one can see why it's important not to take away rights which have previously been granted to trademark owners. I don't think the UK legislature has any such compunction, because I think they've done that several times before, and looking at the implementing legislation, there appear to be no relevant transitional provisions or savings or anything. So I think an old UK trademark, which turned out to be caught by this new absolute or extended absolute ground for refusal, would be declared invalid. Whether I'm right on that or not really doesn't matter for your purposes, because what you have to do in the exam is apply the law as it is. And I can't imagine the examiner asking you anything on the basis of this Textalis case, because it seems to me that it's particularly an EU trademark issue rather than a national trademark issue, and EU trademarks are outside the scope of the syllabus. However, the examiner has been known to step outside the scope of the syllabus on occasion, so anything's possible. I just think this is just too obscure a point to spend any time on. But having said that, obviously the wording of the absolute ground for refusal is pretty important. Next we move on to patents, and there's a case from the European Patent Office, Technical Board of Appeal, on patentability of plants. Well, the exceptions to patentability do crop up occasionally in the exam, so it's worth having something up your sleeve, but knowing the usual student aversion to anything to do with patents and the special degree of obscurity of this little corner of the patent field suggests that you shouldn't spend too much time on it. And really there's not very much going on here that you need to write about anyway. Basically what happened was that in the tomatoes and broccoli 2 cases, the enlarged Board of Appeal in the European Patent Office, which is supposed to be the body that receives all the really, really difficult questions, said that it's okay to have a patent for plants in certain circumstances. We won't go into those. The European Commission then sent a note to the European Patent Office, said, but this conflicts with the Biotechnology Directive, and all our member states, who are also many of them your member states, have signed up to that, so they can't have that. So the European Patent Office made some procedural changes to accommodate what the European Commission was telling it to do, and in this latest case, which involves pepper plants, the Technical Board of Appeal has said we're not going to have regard to those procedural changes which were made at the request of the European Commission. As far as we're concerned, the enlarged Board of Appeal's decision in tomatoes 2 and broccoli 2 still stands. The solution to this has been that the President of the European Patent Office has made a new reference to the enlarged Board of Appeal. If there's anything in that that you can make an exam answer out of, you're extremely clever. Everything's up in the air. You need to come back in a couple of years' time and see whether the enlarged Board of Appeal has done anything with it. And you're not going to do that. And that's going to be far too late for the exam. Much more important is, well, anything that you get from the Supreme Court and anything which has a bearing on substantive patent law, really. So Actavis against ICOS is a significant case, and the subject guide, the pre-exam update tells you a lot about it. I think it tells you more than you need to, because it's telling you stuff that you were never told in the module guide to start with. So let's look at the sort of headline that might be of use to you in an exam question about inventive step. This was a patent which claimed a second medical use. So this is not uncommon in the pharmaceutical field. You've got a compound which has certain therapeutic effects, then you discover some other therapeutic effects, and you can go back to the patent office and get a second patent for the new use that you've found. That's been going on for years, nothing controversial about it really. It is slightly complicated, but there's nothing particularly difficult about it. This patent, though, focused on the dosage information, and there was an argument about whether the claim was obvious. In the patent field there is often so much money at stake that you can have arguments about almost anything, but obviousness was the obvious way to attack the patent, and the Supreme Court said, upholding the Court of Appeal, that the claim was obvious because the team being the stand-in for the individual skilled person. You don't have a single skilled person developing pharmaceuticals, generally speaking. The team developing a drug would inevitably go for the lowest effective dose. They would find their active compound and they would work out how little of it you could give to a patient to achieve the desired effect. You don't want to give a patient too much because it might not be good for them, and it certainly wouldn't be good for your profits. So if you try to get a patent that claims just the lowest effective dose for a drug, then you're going to run into problems of obviousness, and I think that's pretty sensible. If you were to dig into it a bit further, you would find, as the pre-exam update tells you, that there's an extensive discussion in the case of the differing approaches of the English courts based on the Pozzoli and windsurfing test, and the European Patent Office, which takes a problem solution approach to questions of inventiveness. That's all very interesting. The module guide never told you anything about what happens in the EPO. It told you about Pozzoli, and Pozzoli is simply a development of windsurfing, which is a much earlier case. So you need to know that, and the 3 or 4 steps set out by the court in Pozzoli are absolutely crucial to answering a question here. That's something you need on the tip of your tongue to do a patent question in the exam. But the contrast between the English and the European Patent Office approach is another matter altogether. If it's not in the subject guide, I think, well, you don't need me to tell you not to study it. You simply wouldn't study it anyway if it wasn't there. I'm not going to tell you not to study it because it would be just my luck for the examiner to set a question on precisely this. But I think if the examiner did that, it would be a real low blow. The final point of interest in this case, which again the pre-exam update mentions, but which really you don't need to know, is that the Supreme Court gave consideration to the question of when an appellate court can overturn the trial judge, because of course the trial judge has got access to all the evidence and so on. It's relatively rare for an appellate court to overturn a trial judge, and it's something they've got to do with great care. Although, as we've seen, it does happen. So that's a pretty important case to know if you're going to try and answer any questions about patent law. And it doesn't stop there. Let me just pause for a moment. That's just to enable me to synchronize the slides and the audio track when it comes to putting this together. Shanks and Unilever. It's in your subject guide because, the module guide rather, because the Court of Appeal decision is important. But the Court of Appeal decision is no longer important because the Supreme Court has overturned it, and also overturned the judgment at first instance of Mr. Justice Arnold, as he then was, and the decision of the comptroller, or you might say of the hearing officer, but the hearing officer acts on behalf of the comptroller, and it's the comptroller who's got the power to make the decisions. Shanks and Unilever is, well, it's now the key case on employee compensation for inventions. And if you know anything about this area, it's a really interesting area of law, and one that crops up from time to time in the exam. It hasn't done for a couple of years, and I think with that Supreme Court handing down this judgment this year, it would be at the forefront of the examiner's mind. So don't bank on there being a question on this, but I think there's a very strong chance. So employee inventors are entitled to compensation. It depends on a number of factors, including whether the invention belongs automatically to the employer or whether they've assigned it to the employer. Different rules apply in those two situations. If the employee was employed to make inventions, basically, then they will be entitled to compensation if the benefit to the employer was outstanding. And that word outstanding has created huge problems, and for many years the key case was one involving a guy who worked for British Steel, whose name I can't quite remember at the moment, whose invention saved British Steel an awful lot of money, but because British Steel was such a huge operation, that large amount of money that it saved was a tiny proportion of its turnover, and the court said that's not an outstanding benefit, sorry. So we had cases which told you when the employee couldn't get compensation, but actually only one, the General Electric case, which gave an indication of when an employee might get something. The law didn't seem to be working terribly well, and it had come to be said that the rule was simply that some organisations were too big to pay. They were so big that any amount of benefit from the invention couldn't count as outstanding. The hearing officer in this case and Mr. Justice Arnold on appeal and the Court of Appeal on appeal from his decision all took into account all the factors. There was no mistake there, but the biggest factor that they had to take into account was the fact that that Unilever's such a large business that the amount of benefit that they got from the invention was pretty insignificant. So the Supreme Court has got round that by saying, no, you don't look at the Unilever group as a whole. Look at the part of the Unilever group that's concerned with inventive activity. That's where Mr. Shanks, or Professor Shanks, I think he was, works. That's who employs him. That's the right entity to consider when you're looking to see whether it's enjoyed an outstanding benefit from his work. So it looks very much as if the too big to pay principle, which was never a principle anyway, is now dead and buried, and a good thing too. There's a lot more I could say about this case. I'm not going to at the moment, because I think what I need to do is to record a separate lecture on how to answer a question about employee compensation. As I said, it does crop up from time to time, although I think it was only half a question last time I saw it. And finally, a case the purpose of which I find very hard to understand. It's a patent court case. It concerns how to interpret patent claims, and it follows the approach prescribed by the Supreme Court in Actavis against Eli Lilly in 2017. That was definitely an important case. But this isn't particularly new. It was decided on the 19th of January 2019, so why was it not in the module guide in the first place? Has anything happened to make it particularly important, such that it needs to be mentioned now, when it didn't need to be mentioned when the 2019 edition of the module guide was put together? I don't know the answer to that, but I'm pretty sure that actually nothing has happened. But there is at least something useful in it, which is that the judge has worked his way through the Actavis questions and has said that when you ask the first question that the Actavis case says you've got to work through, which is, does a variant infringe any of the claims on a normal interpretation? That is quite narrow. You've got to interpret the words in the claim in the context of the specification as a whole, looking at it through the eyes of the skilled person, applying that skilled person's common general knowledge, but you don't do anything more radical than that. It's not quite just a literal interpretation, but it's coming close to it, and that's your starting point. And that's the whole point of Actavis, and the fact that it's got, I think, 3 questions to work your way through. You start with the simplest one. You say, just looking at this claim in a perfectly normal way, is what the defendant is doing an infringement? And if you can answer it on that basis, then you don't need to go any further. The point about the later questions is that they broaden it out and they introduce other possibilities. They adopt a purposive approach to what the claim is supposed to mean. But when you're just looking at that first question, a purposive approach is not called for. It's simply a matter of looking at the words, looking at the context, i.e. what is in the rest of the specification, and thinking about the skilled person and their common general knowledge. If you have to look at the later questions, that's when the purposive interpretation comes into play. Well, as usual, that's turned out to be probably twice as long as I thought it was going to be. There's some useful stuff there. There's some stuff which I've described so that I can tell you that you don't need to know it. But if you just read through the pre-exam update, it would be less easy to see what may and may not be important. So I hope that's performed a useful service. I'm going to go on to do a lecture on how to answer a question about employee compensation for patents, and I think also something about how to answer a question on patent claim interpretation would be called for as well. So watch out for those. I'm not quite sure where I'm going to publish them, but I make sure I publicise them when they become available. Thank you very much for listening. Good luck in your studies. I'll speak to you again later.